This is a summary of the judgment which the Supreme Court is handing down this morning in the case of TW Logistics Limited and Essex County Council. This case raises some important questions about the law relating to town and village greens. If an area of land is registered as a town and village green under the Commons Act 2006, members of the public are given the right to use the land for recreational activities, which the owner of the land is legally required to respect. But the town and village green that was registered by Essex County Council in this case is somewhat unusual. There is not a blade of grass on it. Rather, it comprises an area of concrete of some 200 square metres on or close to the water's edge in the working port of Mistley in Essex. For many years, that area of concrete has been used by local inhabitants for walking with or without dogs, or standing and chatting. But it's also an area across which port vehicles, including heavy goods vehicles, have been regularly driven. The two sets of activities, the recreational activities of the local inhabitants and the commercial activities of the port owner, have coexisted without any real difficulty for all these years. But in 2008, a dispute arose in relation to a fence that was put up on that land close to the water's edge. And no doubt with a view to clarifying and protecting the rights of local inhabitants, a local resident, Ian Tucker, applied to Essex County Council to have the 200 square metres of land registered as a town and village green. The council appointed an inspector to conduct a public inquiry, and he found that the statutory criteria for registration as a town and village green were satisfied. That is, the local inhabitants had been using the land for recreational activities as of right for the requisite 20-year period. Essex County Council, in line with the inspector's recommendation, registered the land as a town and village green in 2014. The operator of the port and the owner of the land in question is TW Logistics Limited, who I shall refer to as TWL. TWL has brought a legal challenge against that registration of the area of the land as a town and village green. TWL's challenge was unsuccessful before Mr. Justice Barling and before the Court of Appeal. TWL now appeals to the Supreme Court. The Supreme Court unanimously dismisses TWL's appeal. The judgment is given by myself and Lord Sales, with whom Lady Black, Lady Arden and Lord Stevens agree. TWL's primary argument before the Supreme Court is that the effect of the registration is to render criminal the continuation of its commercial activities on the area of land, and that one cannot validly register land as a town and village green where that is the effect of the registration. In rejecting that argument, it has first been necessary for the Supreme Court to clarify the respective rights of the landowner and of the public following registration of land as a town and village green. This has involved a careful analysis of past cases. What emerges from that analysis is that on registration, the public acquires the general right to use the land for any lawful sport or pastime. However, the exercise of that right is subject to what has been termed the give and take principle. That means that the public must use its recreational rights in a reasonable manner, having regard to the interests of the landowner as recognised in the practical arrangements which developed to allow for coexisting use of the land during the 20-year qualifying period. In practical terms, what that means for TWL in this case is that TWL has some leeway to intensify its use of the port with a corresponding increase in HGV movements across the land that is now a town and village green. TWL also has the right to undertake new and different activities, provided they do not interfere with the rights of the public to use the land for lawful sports and pastimes. Having clarified the respective rights of the landowner and the public in relation to the use of the land, the judgment of the Supreme Court moves on to consider directly whether TWL's continuation of its commercial activities on the land will contravene the criminal law if that land remains registered as a town and village green. TWL has particularly relied on two provisions in two Victorian statutes, Section 12 of the Enclosure Act 1857 and Section 29 of the Commons Act 1876. But in interpreting those statutes, the Supreme Court reasons that the retention by TWL of its right as landowner to continue with its commercial activities means that those activities are warranted by law. And because those statutes are concerned with criminal public nuisances, and because being warranted by law is a defence to a public nuisance, those commercial activities do not constitute criminal offences under those statutes. Given the Supreme Court's decision on that primary argument, it is unnecessary for the court to rule on whether, had TWL's commercial activities been criminalised, that would have been a bar to registration of the land as a town and village green. The Supreme Court also rejects a subsidiary argument of TWL that the quality of the user by the local inhabitants in this case was not such as to qualify the land for registration as a town and village green. TWL's appeal is therefore dismissed, with the consequence that the registration of the area of land as a town and village green is valid and remains in force.